Support comes from Mosby Building Arts, helping homeowners trade out old windows for modern, energy-efficient windows with curb appeal. Estimates at callmosby.com.
This is St. Louis on the Air from St. Louis Public Radio. I'm Sarah Fensky. A unanimous Missouri Supreme Court has created a big mess for politicians, clerks, and even voters. The court says it's following Missouri law. The state-appointed police board has taken the city of St. Louis to court with testimony focused on what the meaning of revenue is. And a couple is suing a St. Louis fertility clinic for mishandling and even destroying a clutch of eggs. But the clinic says it did nothing wrong. Who has a good argument and who should be laughed out of court? Today, we've convened 3 top lawyers to help us answer those questions. Yes, our Legal Roundtable is now in session. And today, it includes Eric Banks. He's a former city councilor and former state prosecutor. He's now in private practice at Banks Law. Eric, welcome back.
Thank you for inviting me.
And today, we're also joined by Erica Slater. She's a founding partner at the Clayton law firm Gunn Slater. She's also a judicial commissioner in St. Louis City. That's the commission that interviews and selects judges to fill vacancies for the 22nd Circuit Court and presents those candidates to the governor. And some big breaking news here. She also just won a huge verdict in Illinois. Erica, we're so glad you still have time for the little broke people.
Oh, come on. I'm happy to be here. Happy to see you.
And congratulations on the $38 million victory.
Thank you.
And last but not least, today making his Legal Roundtable debut is Benjamin Wilson. He's the Stanton First Amendment Fellow in the First Amendment Clinic at WashU Law, which represents clients in matters advancing and defending freedom of speech, press, and assembly. He's clerked for federal district court judges, and he's a former civil litigator, mostly in toxic torts and personal injury. Ben, thank you so much for joining us today.
Thank you, Sarah. Great to be here.
You feel ready for this?
Well, as ready as I'm going to be.
Okay,
So, yeah.
That's all we hope for. Right. Yes. Okay. So the state has seen a flurry of litigation over the new congressional maps pushed by President Donald Trump and approved by Missouri lawmakers. The Missouri Supreme Court previously rejected a lawsuit saying the legislature can't draw new maps outside the 10-year census cycle. So score one for Republicans. Now, critics of the map still had hope because thousands upon thousands of people signed petitions seeking to block these maps from going into law. Surely the people would get the right to vote before the maps go into effect. That's how referendums are supposed to work. But in this past month, the Missouri Supreme Court heard a lawsuit seeking to put the maps on hold while the referendum process played out. And the court said no. So that's led to this really confusing situation. It has us voting in the August primary under the new maps. And then if the petitioners have enough signatures, we might vote in November to throw out the primary maps we just used. Ben, do I have that right? Can that possibly be the result the Missouri Supreme Court is giving us at this point?
That looks like where we're headed. Yeah, we're on collision course for both those things to happen. The only thing I would add is that whichever way the Secretary of State goes with certification or non-certification, there's going to be further litigation after that because I believe, I would expect the losing party to appeal that. So there's going to be more court decision after that, and it's going to be quite harrowing, I think. But reading these decisions, it just looked to me like the Supreme Court wanted to push this back. They didn't want any part of it, and they were like, we're going to kick this back to the politicians to sort this out and the voters eventually. But.
And that politician, this is the Missouri Secretary of State, and he's basically saying, hey, I am not going to go ahead and say there are enough signatures here to go ahead with this vote in time to get that vote in before August. Eric, am I reading that right?
Anytime you have more than 100,000 signatures than what is required, it is blatant politics for the Secretary of State to not make a decision on this.
Yeah, he's not saying you don't have enough signatures. He's saying I'm just sitting. I'm waiting. They turned these in. They turned these in months ago. This seems like exactly the sort of thing, Erica, where you'd file a lawsuit and the court would sort it out. Why is that not happening here ahead of when we all have to vote?
Well, I think that you can't separate the legal issues, obviously, from the political background. And the fact that we have a national political background and then looking at the statewide issues in our own Constitution, as Ben said, this is a collision course to see how this all nets out. And I think that throwing it back to be, the court basically said the way the politics played out here is legal. And beyond that, they're going to dig their own grave. I know that our state has been very red over the last several years, but at the same time, we know from watching national politics and examples in many states throughout the last couple decades that every action has an equal reaction, and the kind of stink of politics here can't be separated from the court's opinion.
So I'm looking at this and I'm going, okay, I don't know anything about the law other than what I learn from 3 expert lawyers once a month. So that's not very much about the law. But I'm just looking at the practical effect and I'm going, this is a recipe for chaos. Ben, can the Supreme Court look at the practical effect of how something will play out? Or is that not part of what they're supposed to be doing here?
That's a great question. I mean, I'm reading these opinions trying to suss that out. Like, do they have an option? And I guess my reading of these cases is they're really quite focused on specific issues. And the court, I think, is, just focused in on those issues. So, it's frustrating, but I don't really see, unless the court had come out a different way on the merits previously or in one of these, I don't really see an avenue for the court to look at it like equitable principles or what we might, public interest and things like that. There's not really a hook for that.
So you think the court is kind of doing what the court had to do?
Yeah, for the most part. I mean, they could have come out the other way on the merits, but
not here.
But as far as equitable principles or looking beyond, into the politics, the court just said directly that they can't comment on the prudence of this or the political nature of it is beyond them. So, unfortunately, that's
Erica.
And that's exactly what the court can do by saying we're staying out of the politics. Mm-hmm. And we looked at the legality of can they do what they did, whether, no matter how those political decisions clash together. So arguably, the Supreme Court's decision here, although it was given immediately, which is sometimes required, they can say we stayed out of the politics in the way that they ruled.
You mentioned it was given immediately. This was something that actually shocked me in all my years of waiting for verdicts to come down. I have never heard of a state Supreme Court ruling in the very day that they heard arguments. Eric, am I just missing what happens?
Well, not only is that shocking, but I was in the audience when the cases were being argued, and I was very, very impressed by the bedside manner and the genteelness of the judges. The presiding judge treated everybody with dignity. It was a very pleasant experience, but only one judge had any questions, and typically with an oral argument before a court of appeals, they really get into the weeds, and it's something I find to be nerve-wracking because I have to, in any case I cite, I'm going to have to be able to defend it. But there was none of that, and which is great if you give an argument.
Sure.
That decision was reached so quickly. By the time I left Jefferson City and got back to St. Louis, social media was already blowing it up.
Wow.
And they had to have the decision written ahead of time.
Because it was not a short decision. It wasn't just one of these one-pagers that you see after a hearing sometimes.
Yeah. I mean, AI is good, but it's not that good. So they had that decision written, and I'm not going to say anything to disparage a sitting judge, but it's kind of like, well, we're going to let them have their say. And unless a miracle occurs, we're going to go with this opinion we've already written.
Yeah.
And the miracle, from my point of view, did not occur, so that's why they went with it.
Could they have just said, we're not even going to bother to do oral arguments on this? We've read this law. This law seems clear to us. Is that an option?
Perhaps, but I think it's more transparent and fair. At least let the parties have their say. And there were world-class attorneys. There were 3 cases that were argued. 2 of them were joined together. But and I'm not disparaging Missouri attorneys because obviously I'm one of them, but they had some heavy hitters from all over the United States who do this for a living, and it was like seeing the Oscars or something. I mean, where else am I going to be in the same room with this kind of national legal talent?
Boy, that's some really interesting context there. I'm fascinated to hear this. I'm wondering if either of you, not to put anybody on the spot, but is anybody aware of another instance where the Missouri Supreme Court or a different state Supreme Court would rule that quickly, that they would have it done by the time Eric is back to St. Louis? That's like a 2-hour drive.
I actually did find a couple of cases. I was super surprised by this, and I liked your question. And so I did a quick research on it, and I found a couple of cases in 2024 when the Supreme Court issued opinions the same day as oral arguments. Super unusual, but it does happen. And one of those was the Amendment 3.
That's interesting. So it feels like the couple ones you found were recent. Is there anything about these particular cases that you think makes them, here's why they were acting so fast on this?
They are all election and voting related. All the ones that I found. So
maybe they want to give the clerks that go ahead. Well, okay, we have to decide this. Unlike Denny Hoskins, we're not going to let this drag out. Erica, do you think that's maybe part of the thinking?
Yeah, absolutely. And I guess it's interesting to hear Eric talk about the manner that the hearing was held. I mean, the whole court knew what was happening. And yes, going forward with the oral arguments is an important transparency part. But I mean, as you said, the opinion was written and we were going through the motions, it seemed like. But in the court's function, as you said, Ben, they've needed to decide some of these things based on referendums and petitions and signatures and how that has interacted with the political deadlines and election deadlines.
What does our ballot even look like for August?
Exactly.
This seems to give some clarity.
And what mandate does that give any of the candidates if they're voted, into a position under one map that is not that is potentially up in the air?
Yeah, it just seems crazy to me to think we're going to vote under maps that could be chucked out months later. If you're listening to our conversation today, you can give us a call with any questions about the legality of this. We'll try our best to try to answer it. We're at 314-382-8255. That's 314-382-TALK. I do want to mention one new wrinkle in this. After this Missouri Supreme Court ruling, backers of the referendum then filed a new lawsuit. This time it's against the Secretary of State, Denny Hoskins, the guy who's been sort of sitting on these petitions, saying, I'm not going to take action until the day I'm statutorily mandated to take action. Ben, do you see any likelihood of success on this one?
I guess the issue is, there's a statute that gives the Secretary of State, time to make the decision, and it doesn't appear to be any other statute or, rationale that would accelerate that the court could enforce. They make a very interesting argument. They say that the Secretary of State has already declared that the petition was unconstitutional or invalid for some reason, so he's made up his mind already, and there was a lawsuit about this last year in federal court. So they're saying, well, look, he's already made a decision in his mind logically, so just enforce it and make him announce it, Judge. But I don't.
It does feel like they're reading that right, that he's already made up his mind, but it's like, does that even matter? Eric, do you think there's any chance this is going to lead to a different result?
I don't think so. And on one hand, he has the right to postpone his decision. But on the other hand, everybody knows why he's postponing the decision.
I think that's right. And it sounds like he's going to get away with postponing his decision. Like that, again, that's where I go, where are the courts? Shouldn't the courts save us here? Erica, give me a reason not to despair.
Well, like Eric said, anytime there are timing provisions in any statutes or laws or even rules of the court, that's the time. And here, that's why it's the collision course. It's the way this has all lined up politically, and there's really nothing you can do to not allow the official to take the time. Like, you can't ostracize him for that. It's your right to take that amount of time, no matter the reason. So here we know there's a pretext, but we'd be in chaos if all of a sudden we were changing those timing rules. So the court can't do anything about that.
And here we are still in chaos. But Eric.
It's kind of like a negligence case in the state of Missouri. You have 5 years to file your action before the statute of limitations is going to bar it. Now, the plaintiff could wait 4 years and 364 days before they file it for whatever reason. I wouldn't recommend it, but for whatever reason. And there's nothing anybody can do about it. You can't run into court and say, well, they filed this case 1 day before the statute of limitations. Well, so what? They get 5 years.
We're talking to our legal roundtable today. That's a dose of some truth time from attorney Eric Banks. We're also joined by Erica Slater and Benjamin Wilson. We're going to take a quick break. When we come back, we're going to talk about another sort of mass of lawsuits, this related to the state-appointed police board versus the city of St. Louis. This is St. Louis on the Air on St. Louis Public Radio.
Hi, I'm Laura Hamden, and my colleague Jessica Rogan and I are your daily hosts of the Gateway newsletter. We meet with the editors in the STLPR newsroom every weekday to bring you the top local stories of the day in a quick and easy 6-minute read by 6 a.m. In an age of overwhelm, it's a refreshing, thoughtful take on the news day, if we do say so ourselves. Fine-tune your daily news habit with the Gateway newsletter. Subscribe at stlpr.org/gateway.
Welcome back. I'm Sarah Fensky. I'm the executive editor of St. Louis Magazine. I'm here filling in for Elaine Chalk because today is our monthly legal roundtable. We convene 3 of the top attorneys in town. They can explain to us what's up and why, what we don't understand about the law that sometimes seems so mysterious and so unfair. We're joined today by Benjamin Wilson. He's the Stanton First Amendment Fellow in the First Amendment Clinic at WashU Law. We're also joined by Erica Slater, a founding partner at the Clayton law firm Gunn Slater and a judicial commissioner in St. Louis City, and Eric Banks, an attorney and mediator at Banks Law. So there is a matter underway in at least 2 different circuit courts. It has drawn multiple lawsuits. I believe at this point there are at least 5. Most of these lawsuits challenge the state's control of the city's police department. And one of the city's lawsuits, which it has filed, also asks that if the state takeover stands, the judge would declare how much they're required to spend on police. They believe that the police are trying to say that they are getting a bigger share of city revenue than they should. Well, the big news this past month is that the state-run police board also filed a lawsuit. They filed this lawsuit against the city. They're seeking a ruling that says the city has to spend far more on police than it has been spending. Now, that's already a matter at issue in the city's lawsuit, but the police board has said this is a matter where we need clarity and we need it fast. Ben, they are seeking an expedited ruling. Do they have unique abilities to get an expedited ruling that the city itself did not have?
Yeah, I think they do. They cited this really funny statute I'd never heard of before, but it was passed in 1961, and it gives police boards like authority to use office space and use telegraph lines and watch boxes and firearms and all kinds of equipment. They can just like use it for their purposes. But also in that statute is this provision that allows them to bring a mandamus to compel action by the city or whoever's opposing their, the revenue request or something like that. So they actually had something. I was thinking this is like the big red, the easy button. You push it and you get an expedited case, and it's easier, it's faster, but there are also some procedural obstacles to it. And so the city brought that up and has been taking advantage of some of those procedural issues.
Okay, so I'm absolutely floored. This obscure law from the 60s that lumps in your right to go to court with some other random rights that police boards have. What are the procedural obstacles? Any you'd point to as like, oh, this is interesting. The city can now do this.
Well, one that the city raised is that the board has to give like at least 7 days notice before they file this motion for mandamus. And so the city's saying you didn't do that. There was this closed door meeting when the board authorized filing the suit.
And it happened like the next day, right?
Yeah, right. And then they filed immediately the next day. So the city's saying you didn't comply with the notice requirement here.
Is that something a judge would normally take pretty seriously, or is that more like that can be optional depending on the court?
honestly, with this statute, I do not know how
Not
the
a
judge
ton
is
of
going to look at
precedent
that.
here.
Yeah, there's not that I was able to find. No.
Okay. So the big question here seems to be like, what is the definition of revenue? And that, like, I'm no accountant, but that feels like something that I learned in high school. Eric, am I crazy to think it's weird this would be the subject of a day-long hearing?
No, and I think the real issue is whether or not the Rams settlement should be considered revenue for budgeting purposes that is included in the mix, or does the Rams settlement enjoy a special carve-out so that it is not affected by the formulas that the police board get to use for the apportionment of revenue? And because it can go either way, somebody is going to win big, somebody's going to win terribly, and the only sure way you can anticipate what's going to happen ahead of time is for reasonable minds to prevail and the case settles.
Yeah, and I don't think that's going to happen in this case. I don't see the city and the state coming together and saying, okay, let's just work this all out in a back room. They had lots of time to work this out in a back room. Erica, what do you make of this whole morass involving lots of litigation, state and city?
I really look at this. I mean, yes, I'm here as a lawyer, but I'm a city resident, and that's where my perspective comes from. This isn't my area of law day to day necessarily. And you would hope, just from an outside perspective, that this Rams money is a special category, because if we took in, those kinds of funds, in the future, there could be some other corollary, whether it's settlement money or something else. If you just throw it into the budget and redistribute it, per year, that's not the best use of those funds, and there's been so much debate and factions coming in of saying how we should spend that money, and if you just filter it through a predetermined pro rata, then that doesn't maximize that kind of money. So general revenue, does that mean the routine budget? It's hard to say. And then you have on top of that issues, the political issues that are involved here with the state takeover, and then putting a money component into that. Who's responsible for funding, the demands of the board? That's a big deal. I mean, I'm sitting here is this taxation with a little representation? What are we looking at here? Yeah. So I think the lawsuits will continue.
Yeah, the lawsuits are definitely continuing. And I guess that's where I start to get a little confused, because when the police board kind of got their fast pass, can I call it that? Yeah, Ben's saying I can call it that. Thank you. When I have the wash you imprimatur on what I'm saying, I feel good. One of these lawsuits that was filed challenging this, I believe this was the first one that was filed. It was filed by the nonprofit law firm Arch City Defenders. That one went to trial, I believe, in Cole County this past month. And so they were slowly moving through the courts, having the process they're allowed to have. What happens if these lawsuits end up coming to contradictory rulings? What if in Cole County they're like, okay, you're entitled to 23% because of this, and then we're coming out of this case in the city where they've got the fast pass and it's saying, oh no, we're going to give you all the Rams money plus this. What happens there?
Well, I do think that the parties will need to inform the judges in the other courts of any rulings that may be pertinent to that case. And I'm sure that whoever wins or loses one of those rulings is going to be very quick to bring that up in the other courts. But then there's going to be the issue of, for the respective courts looking at the issue, are we addressing the exact same issue? Are these the same facts and the same legal issues here in my court as was decided previously? So that will also be a matter of briefing and argument.
Let's say that they can make the case it is the exact same issue. And I think many of these are going down slightly different paths. But let's say there is one that's exactly the same. If they can make a persuasive argument of that, does the guy who gets the ruling first is the guy who wins?
Yeah, I think there's a really strong argument there that other judges in other cases who are handling the same issue, if it was already decided one way by another court, they probably need to defer to that and adopt those findings. But it will be briefed and argued, and so we'll see.
Yeah. Eric?
It's kind of like, what is the best way to win an appeal, to be the appellee? Because the appellant is going to be the one with the greater amount to decline, because the appellant is trying to convince the Court of Appeals that the trial court made a mistake. So I like being the appellee. I don't like being the appellant.
You want to preserve the status quo a little bit, not be trying to fight it. Erica, it seems like no matter what happens, we're going to have to end up in the Missouri Supreme Court on this whole question of state control and city expense. And do you see any path around that? Is it possible one of these circuits just, issues a ruling and then that solves everything?
Well, I can't, especially if we have contradictory rulings. That will be extremely required. As you were hoping that the buck would stop there on the last issue, this one it may, since it's would be interpreting the statutes and how they play out. But I think that's the only way there would be any clarity. I don't think a circuit court ruling is going to. There may be some precedent, but there'd still be an opportunity to appeal. And the Supreme Court may get the final word no matter what.
I do want to mention one thing. Judge Joan Moriarty, who's here in the St. Louis Circuit, she is the one who's hearing the fast track case that was brought by the police board. And she handled a different case that reached its conclusion last month. This one also involved the St. Louis City Police. She found the police had, quote, purposefully violated the state sunshine law to avoid providing records to the Post-Dispatch. And I mention this in part because our friend Dave Rowland, who's frequently a panelist on this show, just a great guy. He was the lawyer on this one. He points out that the Post-Dispatch did not ask for civil penalties and that the judge really sent a statement by nevertheless issuing a $5,000 penalty. Ben, I know First Amendment law, this is kind of your baby here. Do you think we should read that as sending a message? Is Judge Joan Moriarty potentially saying, hey, police department, you're a little out of line here?
Well, far be it from me to disagree with the great Dave Rowland. I mean, and this is a testament maybe to his advocacy that he got way more than he requested.
Yes.
But they did plead and argue that the city had purposefully violated the Sunshine Law, and there are statutory penalties for that. And it doesn't really look to me like there's a lot of discretion there. I mean, it's pleaded that way in the petition that seeking finding both a knowing and purposeful violation of the Sunshine Law. So once the judge finds that it's purposeful, I think they almost always give a fine, and if Dave wants to return that, he's welcome to do that.
Dave is not going to return that. Eric, so we should probably not read this ruling by Judge Moriarty as telegraphing where she could go on the revenue question in an unrelated lawsuit?
No, but I will say I filed a couple of class actions against the city, and I magnanimously put in my prayer, I don't want any money from this. I want any fees that would be collected would be donated in equal part to legal services and Arc City defenders. But that doesn't stop the judge from enforcing the statutory duty to award me fees if I wanted them. If I want.
Even if you are sort of like, I don't want these fees, the judge can still be like, Eric, you get these fees.
Yeah, and that way it makes me look magnanimous.
And so did that work? Did
the
judge?
It did not.
No, it did not.
No. I lost. So it was academic.
Academic, but a good experiment. I appreciate you doing this on behalf of the legal community. Okay, we're speaking of politics here. A federal judge in St. Louis tried to use a man's criminal case to make a point about national politics. This is U.S. District Judge Joshua Devine. He was presiding over the case of an undocumented immigrant from Honduras. Both prosecutor and defense agreed the man should be deported after serving 4 months in jail. Judge Devine had a different take. He asked defense attorneys to explain why he shouldn't sentence the man to more prison time than federal guidelines suggest. Here's a quote. The federal government from 2021 to 2024 did not deter illegal immigration. It did the opposite. The Trump administration is vigorously enforcing immigration laws, deterring unlawful immigration conduct, but the previous administration did not. And then he went beyond what these guidelines were, sentenced this guy to a year in prison. He said he was doing it as a, quote, deterrence to Biden's policies. Erica, I have read a lot of legal documents. I can't say that I've ever seen this sort of argument in what is sort of a bread and butter criminal case.
Yeah, and the penalties and the deterrence factor are built into the law most often, and in the sentencing guidelines and things like that. So it is unique to see this type of opinion with the type of explanation that was given for the sentencing. So it's, in my mind, very, very unique.
Yeah, and this caught the attention of the appellate court. They wrote, quote, "A criminal defendant should not be punished for a prior administration's immigration policy. The district court abused its discretion by focusing on immigration policy of the former president." So this didn't really work out for this judge. If he had just given this guy 12 months, do you think the appellate court would have been like, can't go around the sentencing guidelines?
I don't think so, but keep in mind that the good judge has a lifetime appointment, and his ego perhaps could be slightly bruised by the slap on the wrist that the appellate court gave him, because every district court judge in the United States gets paid exactly the same. So they keep score by different metrics than most of us would.
Yeah.
And one of the metrics is they don't want to be overturned by the Court of Appeals. Makes it look bad when they go to judicial conferences and everything. Well, that's the fellow whose hand was slapped by the Court of Appeals. But it also reminds me of the old saw. What's the difference between God and a federal judge? God does not believe she is a federal judge.
That's it. Eric, you've got some good bon mots today, I must say. Like, that's a good one. And that's interesting to think of that motivation, that federal judges don't want to get overturned. In this case, Ben, it feels like he was almost asking to get overturned. Do you care to speculate on his motives?
I do not care to speculate on his motives.
But what do you think could possibly be driving this?
Well, one of the factors I think is, Erica mentioned, one of the factors is deterrence. And so depending how broadly you read deterrence, you could maybe, shoehorn in immigration policy and those considerations to deter other illegal immigration action or something like that. So I guess there's a tenuous argument. But
this could put an individual immigrant on notice, or this could put a presidential administration on notice. You're going to see these guys do more time in jail if you don't change your immigration policy.
Well, deter other potential crime by individuals.
So if you're an immigrant, you might say, "Oh shoot, like these judges are out for me." That seems somewhat persuasive, Erica. I don't know. What do you think?
Well, and I think that I guess you can read a couple things into the way the opinion was written. The Eighth Circuit Appellate Court is targeting their correction of the sentence to judicial discretion, which happens in appeals every day. They didn't censure him or anything. It's just saying, rewrite this, basically. This part of your reasoning that came out in your opinion shouldn't have come out in the opinion. And I think we learned before we started talking today that because that would go back to the same district judge to resentence, and I believe that's come down.
Yeah, so this is a nice little breaking news bit that our panelist Ben has found out. What has happened since the appellate court said, you shouldn't have done that?
Yeah, well, a new sentencing hearing was held, I think a week ago or a little over a week ago, and it turns out the judge issued the same sentence as he had before, 12 months and a day, and plus fines and things like that. So it actually came out to be the same sentence. My understanding is that the defendant here, Mr. Rivera-Vasquez, is very close to having served that time anyway, so he'll be out shortly. But
still, this seems odd that the district court is kind of doubling down. Do you think this could trigger the appellate court saying, "Hey, we wanted you to not do this way"?
Well, we don't know. So previously there was an opinion issued with the sentencing that explained all of the reasoning behind it, and that was not, there is no opinion this time, and there's a statement of reasons, but I wasn't able to access it. It's closed.
Everything in federal court is closed.
Yeah, so,
good luck finding anything on Pacer.
Yeah, so we don't know what the judge's reasoning was.
Wow.
You can review the factors and sometimes come out to the same conclusion as long as you've considered all of the statutory factors you're supposed to.
So the appellate court would be able to look at what he filed even if you and I as laymen can't?
Oh yeah, that would be on the
Okay.
record on appeal. Although the defendant here filed a notice that they're not appealing it.
They're not going to appeal. Wow, that's interesting. And we should note one other side wrinkle, and this was all brought to light by Tony Messenger of the St. Louis Post-Dispatch. I want to credit him for breaking what I thought was a really good story. Eric, so this guy is now, this is going to stand, but this original thing that the appellate court wrote, they didn't publish their opinion. Should we read anything into that? What does that even mean for those of us outside legal circles?
I like published opinions. I wish that the opinion had been published. Probably it means that we're not going to make a big deal out of this. We're going to slap the judge's hands, go and sin no more, but we're not going to make a big deal out of it.
Yeah. I think that probably is the right way to read that. But now Tony Messenger has made a big deal out of it, so it's kind of out there. I love when the journalist can mess with things. That's my bias right there. One last question on this subject. If a defendant ends up serving 12 months and 1 day, and the appellate court says that's wrong, is there any recourse for a defendant? I know we don't have any criminal law specialists here on the panel today. I see people saying nobody is sure on that. No? Okay. Well, we'll bring this up with next month's panel. I'm sure they will get to the bottom of that. Well, we are talking today to our Legal Roundtable. We're talking to attorney Eric Banks. We're also joined by Erica Slater and Benjamin Wilson. We're going to take a quick break here. And when we come back, we are going to talk about a case that was filed against STL Fertility. That's a fertility clinic here in St. Louis that supposedly did a very bad job of taking care of someone's eggs. This is St. Louis on the Air on St. Louis Public Radio.
Support comes from Gemma, architects, planners, and designers seeking to bring joy to their clients and communities. Details at gemastl.com.
Welcome back. I'm Sarah Fensky. I'm in for Elaine Cha because today is our Legal Roundtable. I am joined by three brilliant lawyers who are helping us understand more about what's happening in our judicial system, all the cases we may hear about on the news but don't quite make sense. Once you talk to lawyers, it does make quite a bit more sense. Today we're joined by Eric Banks. He's a former city councilor, former state prosecutor. He's now at Banks Law, where he serves as an attorney and also a mediator. We're joined by Ben Wilson, who's the Stanton First Amendment Fellow in the First Amendment Clinic at WashU Law. And we're also joined by Erica Slater, who's a founding partner at the Clayton law firm Gunn Slater. Just won a $38 million verdict in Illinois. This firm is very new and on fire. So, of course, we have to talk about a medical malpractice case. That's the rule when we have Erica on. So, Erica, there's a Louisiana couple, and they're suing a fertility clinic that's in Creve Coeur. And they say because of what it did, they lost all 22 eggs that were ready to be fertilized for IVF treatment. And, if you know anybody who has gone through this treatment, it is not easy to harvest these eggs. These are so emotional cases. It's so difficult for families that are dealing with this. I'm wondering, does that mean this is going to be a giant legal verdict? Like, if they can show, okay, there were 22 good eggs, and now there are no eggs, are we talking this is another $38 million verdict that some of the plaintiff's firm can bring?
Well, they have several things working against them, and this area of law is really gray. In my opinion. So my main practice area is medical malpractice. And as plaintiff's attorneys, we evaluate and select the cases that we go forward with. And since the ultimate, end of every case that we take is presenting it to a jury, anytime we're looking at fertility cases and issues, there's going to be a lot of emotional appeal. But also practical aspects. So just to give you kind of a counterpoint, I've been approached about a lot of cases where, not a lot, but enough that it stands out to me, that there's a concern that the biological material, either the eggs or the sperm, are mixed, and they, may have a child that is mom's egg, but a different donor sperm.
Like they put the wrong donor sperm into this embryo.
Right. But
That's heavy.
Well, yeah, and I mean, it's a logistical issue when this is happening outside your body in a petri dish, and presenting that kind of case to a jury, think about you have like an adorable, sweet 3 or 4 year old that all that baby or all that family wanted was a baby. And it's almost in the term when we're thinking about medical malpractice is wrongful birth. And to me, it's just not a concept that I can go forward with.
Yeah.
Here, it's a little different because they, trusted the medical provider to secure their biological material. As you said, anybody who's been through it or knows of people who have been through it, extracting the eggs is a really scary and probably the most physical part before actually becoming pregnant of IVF. And it's also the most, you're so nervous about the retention of the eggs they're able to get, if they're able to get any, depending on your situation. So this is a lost chance of a birth, basically. And that's the way we would look at that type of case. But in Missouri, the way medical malpractice law is written, there's a couple of things going on. One, the chapter 538, talks about if you are suing a healthcare provider for providing healthcare, then it falls under medical malpractice law. So there could be an argument here, like, do you regard those eggs as property? And this is in storing the eggs and not destroying them is not providing healthcare, and then you're outside of medical malpractice. Or, as I would expect the defendants to argue, it is a medical malpractice case, which is important because it's subject to things like pain and suffering caps and caps on damages.
You couldn't give more than a certain amount of money as a jury, basically.
Well, no, you can give any amount, and then the law will operate to reduce it. So that's not talked about in front of the jury. So the pain and suffering money is capped in Missouri, and right now the cap is under $1 million. So you can go through the most traumatic medical situation. Your economic damages, meaning, things that you can put on a line item and show that they have a cost, those damages are not capped. But pain and suffering is. And that is, it's a big deal when you're evaluating whether to go forward with medical malpractice cases. As you can imagine, they are extremely costly with medical experts involved. And that's intentional. The law is intentional to shift the dynamics against personal injury plaintiffs because the economics don't work out sometimes. You're not going to spend, $500,000-$600,000 like we do on these types of cases litigating if the maximum recovery is going to not net any money to your client. Nobody's here for the lawyers to get paid and the experts to get paid. That's not fair. It's not justice. It's not compensation that compensates a family for what they've been through. So I mentioned that because when just the idea of evaluating these cases in the jury appeal, there's also economics coming through on the legal side that affect the strength of their case and how it might be litigated.
Yeah, boy, I can see how these types of cases, that this isn't a home run. You'd have a lot of lawyers say, this is just too steep odds. Like, they might have a wonderful story that's important to tell, but...
It is, and just the legal aspects for any legal nerds thinking about this, like an unfertilized egg, is that property? Is that health care? Is that a baby? What are we talking about here? So I think there would be a lot of legal aspects to the case. And depending on the claim of the wrongdoing, that's going to have a lot of emotional impact, even if it's media attention of don't mess this up. I mean, it's a really important thing for families, and it's a really scary thing to go through.
Erica, I got to keep you in the hot seat for one more question because it's so nice to be able to pick your brain on this. I know you just had a big case in Illinois. Is Missouri unique in regard with how low that cap is for pain and suffering damages versus, say, a state like Illinois?
Man, medical malpractice, there's no medical malpractice caps in Illinois. The case we just tried...
None at all.
No, there's no punitive damages in medical malpractice, which is different than Missouri. But the case we just tried in Illinois was a product liability case. But medical malpractice law is a really strange beast. It is so state by state. Like in Louisiana, they have a completely different system that's like an administrative system. Like you don't even go to the court. There's
Wow.
and except under very unique circumstances. And so that type of law, yes, there are caps. I could get on my soapbox about this, about the medical insurance lobby. I would say that, the only people saving any money here are not doctors on their premiums or healthcare providers, but insurance companies are saving money with these caps in place. So,
And I'm sure now we will hear from somebody
Yes.
on the other side of this wondering why we don't have their perspective. We only have 3 panelists, so yes. And I do want to mention that a spokesperson for STL Fertility, this Creve Coeur clinic, they told the Post-Dispatch that it denies the allegations. It says, quote, "The physicians and staff at STL Fertility are dedicated to improving the lives of our patients." They said that there in a statement. Eric, very sad case. Sounds like you can see why a lot of lawyers might not take this case. Do you think there's any recourse for these poor people?
Unfortunately, I do not, and I am shocked that $500,000 to $600,000 in out-of-pocket expenses, not going to the lawyers, but going to the experts, the investigators, the court reporters, the videographers. That is a lot of money. Back when I was doing plaintiff's work, I only accepted one plaintiff's malpractice medical case because they're just so expensive to work out. When I returned to St. Louis in 2012, I sat in on a medical malpractice trial in St. Louis County, and my former classmate, Al Johnson, was one of the attorneys trying the case, and they spent $100,000 in 2012 working this case up for trial. And then they lost the case.
Wow.
It was a defense verdict. And that's a real tearjerker. Not only do you have to go to your client and explain to them why you lost, you have to go to your bank and explain why you lost as well.
That's tough. I mean, it really is a gamble to some extent. But then I think about the other side. I think if I'm defending one of these lawsuits, I might spend that much money mounting my case. I win, and what do I get? I get nothing. Like that seems crazy. I don't know. It feels like our system works until sometimes when you play things out down the road and you're like, wow, that seems really unfair.
Yeah, and it's because in America we have the American system of jurisprudence. In England, they have the British system of jurisprudence. And in Britain, the loser pays for everything. So if the defense were to get a defense verdict, then they could petition the court for whatever they had to pay to work that case up. It's not like that in America.
Yeah, that would be such a different system. Erica, I imagine that would change the entire way that you and your law partner think about practicing law. Like that would just shift all sorts of economics right there.
Well, yes and no. And it's different on my side, we do all of our work on a contingency fee basis. So, it sounds cliche because everyone's heard commercials of how attorney, we don't get paid until you win. Well, of course, that's how it should work because not only people who can afford to pay an attorney hourly should be able to access the justice system. And that's exactly why plaintiffs' attorneys take cases on a contingency fee. But we also bear the burden of all of those costs in working up the case. So if I have a birth injury case and those are the ones that can get into those high expenses, it could be litigated for years and it could be, we could win at trial and then there's no post-judgment interest under the law for defendants. So they get a free shot at an appeal. So we know it's a long-term thing. So in evaluating cases, knowing we bear the burden of those costs if we lose, that has a major effect on the way that we evaluate cases, which is why it is so imperative for us to go forward with strong cases that we believe will be successful and that we will be successful in winning for our clients. Yeah.
And Ben, we have just about 30 seconds left.
Well, I had a kind of a question maybe for Erica or Eric as well. Is my defense experience, plaintiffs usually sue all the potentially liable parties they can, and in this case, the eggs were transferred from here on a truck, then they went to Mississippi or something, they were stored again, and then they went on a truck again,
Yeah.
and moved to Louisiana. And I did find a prior jury verdict, a large one, where the verdict was against the refrigeration company that. So they
Yeah.
were missing some defendants here. We may not have
Yeah,
time for
sadly,
that.
I'm not even going to let you guys answer that question, but that's a great question. And you do wonder, you don't want them pointing to that empty chair and saying, it was the trucking company. You know, that's puts some fear in my heart. We will see what happens with this lawsuit and with any number of other legal matters that we're considering today. But I want to thank our panel for joining us because we are out of time. Benjamin Wilson of WashU Law School, thanks so much for joining us.
Thank you, Sarah.
And Erica Slater of Slater Gun, thank you.
Gunslater, yes. Thank you for having
Gunslater.
me.
I flipped it. Gunslater. Let's say that one last time. Gunslater. And Eric Banks of Banks Law, thank you for joining us.
It's been my pleasure.
This episode was produced by Sarah Fensky.
Our executive producer is Alex Hoyer.
St. Louis on the Air is a production of St. Louis Public Radio. Understanding starts here.
Do you find yourself regularly listening to episodes of St. Louis on the Air? Suggest us to a friend you think might enjoy our conversations. And leave us a review and rating on Apple Podcasts on the App Store. It's the simplest way to help people discover our show. Thanks.
St. Louis Public Radio is a member-supported service of the University of Missouri St. Louis.